You're tuned in to Agriculture Today, and we start our Wednesday show discussing a blog article titled Preserving the Family Legacy. And then to talk about his blog article, we have K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you.
And Roger, as we're talking about this article, as I mentioned, titled Preserving the Family Legacy, what is the biggest hindrance sometimes you see that goes unnoticed and might impact that legacy?
Oh, I think by far lack of planning, not doing anything. That seems to paralyze quite a number of people. It seems many times estate planning, succession planning, business planning, long-term care planning seems so overwhelming that people just put it off, not knowing where to start or being afraid to address some of the issues, being afraid to upset family members for whatever reason. Lack of doing anything seems to be the biggest issue that's out there.
And focusing today on that long-term care planning aspect, why is that something that's so important?
Well, because if you need long-term care and the stats are that about 70% of those that are currently turning age 65 and looking into the future will need at least some degree and some extent of long-term care, and that care is costly. We're looking at about $130,000, $135,000 annually for nursing home care in states across the Midwest. And you're looking at $11,000, $12,000 a month. That's a chunk. And if you haven't done anything to plan for that, you could get to the point with an extended stay and an extended need for long-term care that you start eating up assets that your plan was to transfer to the next generation. Those might be farm assets, could be farmland, farm machinery and equipment, livestock, and that kind of could be very detrimental to your long-term business succession plan.
And you mentioned turning 65, and with that, I think about Medicare. Does that do anything for producers?
Well, Medicare generally only covers short-term rehabilitative care and then only 100% of the rehabilitative care for the first 20 days. And so after that expires, then most families that don't have the assets or resources or didn't do planning will look to Medicaid. But Medicaid is a means-tested program that's designed for the indigent. And so what I mean by that is an applicant has to have very few countable assets to qualify. Typically, your spend down requirement is you've got to spend your own resources and your income down to about $2,000 before you can be eligible for public assistance benefits in the form of Medicaid.
And having the assets that low, is that something they would just need to do right before they would apply for Medicaid?
Well, there's a 5-year look back, and so you can't just transfer your assets away without compensation, without receiving fair market value for them within 5 years of making an application for Medicaid. If you do, the value of those assets are still deemed to be available for you for Medicaid eligibility purposes. So, for example, let's say 2 years ago, I make a Medicaid application, but 2 years ago I transferred property worth $250,000 away. I just gifted it away to my kids. Well, the Medicaid agency, the state agency that runs this combined state-federal program, is going to look back, catch that transfer, and say, well, the cost of nursing home care in the state is $125,000 a year. You're disqualified for Medicaid for 2 years. Now, providing I don't have any other assets, they're going to catch that transfer, and I'm going to have to private pay somehow for 2 years before Medicaid kicks in. That's the application of what's known as the penalty period.
And what about for assets like the gift tax? Does it need to be worried about being taxed or used within that 5-year look back?
Well, that's a good question because those are two separate things. The present interest annual exclusion for federal gift tax purposes is $19,000 per recipient this year. That is totally distinct from the Medicaid rules. So I could gift $19,000 to someone without having to file a federal gift tax return. But if I'm gifting non-exempt assets of any amount, that triggers a Medicaid penalty if I make those transfers within 5 years of that Medicaid application.
So for producers who are looking into Medicaid but also want to have control of their assets still, is there an option for them?
I think the premier option is what's known as a Medicaid Asset Protection Trust, or MAPT, or MAPT. It's an irrevocable trust, and once I transfer assets into the trust, then I no longer own those assets for Medicaid eligibility purposes. But the beauty of this is that the trust can be structured to have specific protections in it, and which many times farmers will want in these situations. I could retain, for example, the right to live in the farmhouse for the rest of my life. And I could also have the trust drafted so that it's an income-only trust, which would allow me to continue receiving rent from the land or dividends from investments held by the trust. And if it's drafted correctly, it's still deemed to be what we call in the tax trade a grantor trust. And so my heirs would get a basis in the trust assets upon my death equal to the asset's fair market value at the time of my death. And that would potentially save hundreds of thousands in capital gain taxes if that land is eventually sold. So you get inclusion in your estate. It's usually not a problem for people because the $15 million exemption right now, most people are going to be underneath that, which means you get a basis step up in the hands of your heirs, and the assets are still not deemed to be available for Medicaid eligibility purposes.
So if we're working to make things invisible to Medicaid, does that impact how things might work with the IRS?
Well, we've got Medicaid rules and we have IRS rules, and they're different. And the IRS views things differently than the agencies that are responsible for Medicaid. IRS doesn't care about the Medicaid no access rule. There are specific rules in the tax code that govern the tax treatment of trust assets, and those provisions focus on whether the grantor retained what we call sufficient strings over the assets or incidents of ownership. And that can be done by the clause language that's drafted into the trust to give the grantor possession, enjoyment, or the right to the income from the property that's put in the trust, and that'll cause inclusion in the estate. Medicaid doesn't care about that. They don't care if you retain that type of an interest. So what they care about is whether you have access to the corpus or the principal of the trust, not the income, but the corpus. And so you can be shielded from having access to the principal, but still benefit financially from the assets in the trust, and it will not cause a problem with your Medicaid eligibility.
So with the Medicaid Asset Protection Trust, that would need to be done before that 5-year look-back period?
Oh, yeah. You want to do those while you're healthy. The sooner the better is always the thing to keep in mind with respect to that. But yeah, you don't want to wait until it's too late. If you create the trust, transfer the assets into the trust, and then apply for Medicaid within 5 years, it's deemed to be a transfer that the Medicaid agencies can grab. So you've got to create the trust. That'll get the 5-year clock starting the moment the assets are deeded into the trust. So the best time to plan, as always, is while you're healthy and have no immediate need for care.
Is there ever a time that's per se maybe too early for someone to do this?
That's an interesting question because there's two ways to look at this. One is we seem to have a misconception that the only people that need long-term care are older people. That's clearly not the case. If you look at the most famous court cases that are out there, even stretching from the U.S. Supreme Court back down through the federal courts, the most prominent cases have all involved young women. The first case that comes to mind is Karen Ann Quinlan. That was back in the 1970s. That was a drug overdose. There was a case out of Joplin, Missouri, which was a car accident. And the individual ended up in a vegetative state, needed long-term care. That was a young lady. There was the Florida case about 27 years ago. And she became incapacitated, and the battle was over whether her ex-husband or her parents could make her medical decisions. Well, those are all kind of like medical decision cases, but they all required long-term care. So is it ever too early? Technically, no. But most young people don't think about these things because they're not thinking of their potential demise. Shelby, as we're younger, we think that we're immortal, we're going to live forever, and these issues aren't highlighted until we get older and more mature and then come to an understanding. I'm not going to live forever, and I need to get my things in order. So the answer to your question is no, it's never too early, but it takes on greater importance as a person ages.
And while we're thinking about all this planning, do we also need to take into consideration spouses or children?
Yeah, effective planning is not just about hiding assets. It's about business continuity. So if you have a spouse that enters care while the other spouse stays at home on the farm, that spouse is known as the community spouse. and they are entitled to what's known as a resource allowance, and they can keep presently up to $162,660 in countable assets, plus the home and certain income protections. That's really the best position as far as Medicaid is concerned, if there is a spouse at home. And there's also a caregiver child exception. And so there are situations where if a child has lived in the parent's home for at least 2 years and provided care that kept the parent out of a nursing home, the home may be transferred to that child without violating the look-back rule. But in any instance, waiting to put your plan in place can be costly. And we always have to keep that in mind.
Roger, I appreciate you taking the time to join us today.
Thanks for having me.
That was K-State and Washburn law professor Roger McEowen. His blog article titled Preserving the Family Legacy will be linked in today's show notes on agtoday.net.